Hi there, I'm Professor Blackmore, and I want to welcome you back to ProfessorBlackmore.com, where our goal is to empower results through real productivity. And if you haven't been here before, I want to ask that you please subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos. And please also follow me on TikTok and Instagram. And I'm coming back to you yet again to discuss further developments surrounding the Kyle Rittenhouse criminal trial. And you are aware that today the judge will provide the jury with the jury instructions, and the prosecution and defense will give their closing statements. Now, the jury instructions will include the judge's final decision on any lesser charges that the jury may analyze in their deliberation. And if you had a chance to catch some of that chaos on TV this morning, then God bless you. But anyway, I just don't know how I'd react to have a judge actually edit the jury instructions on live TV while he's actually reading them to the jury. But anyway, so over the past few days, I've been hearing maybe some information that maybe I disagree with from some of the TV lawyer analysis, and I want to dispel some of the confusion. One thing we've been hearing is that because the prosecution did such a poor job, they now want to include lesser charges for the jury to consider. Now, while I agree the prosecution did not do itself any favors, let's just say, you'll remember in my last video that I showed you how this is all done in real life. And I showed you the Wisconsin pattern jury instruction for the same homicide charges alleged in the Kyle Rittenhouse criminal complaint. And this is what is used by the judge and the attorneys to arrive at the final jury instruction that is given to the jury. Now, this morning, the judge wanted to deviate from the wording of how this is written in the pattern jury instruction, and I, in my opinion, think this may cause some problems in the end, but we'll have to see. And again, the first thing you'll see at the very beginning is the self-defense deliberation. So as you can see here, the lesser charges are already built into the self-defense analysis. And so, in my opinion, while I agree the prosecution didn't do the best job, this was not some last-minute decision made by the prosecution to request lesser charges, because it was the defendant, Kyle Rittenhouse, who would have affirmatively pled self-defense in the very beginning of the case. And lesser charges are a part of the jury deliberations built right into the pattern jury instruction for self-defense. So when you read this, the jury can find the defendant is not guilty of any homicide offense only as it relates to the particular charge or count that they're working on at that particular time, as it relates to that particular deceased individual in that particular count, if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Or the jury can find, for example, that the defendant is guilty of second-degree intentional homicide if the defendant caused the death of the deceased individual referenced in the count with the intent to kill and actually believe the force used was necessary to prevent imminent death or bodily harm to himself, but the belief or the amount of force used was unreasonable. And in addition to the second degree lesser charge, there's also a reckless homicide lesser charge that can come out of this self-defense analysis. And for reasons that I'll discuss later, I actually believe that they're going to choose either one of these. The first degree reckless homicide is the one that I think, if they're going to choose either one, that they'll choose. But as you can see, it gives the jury a chance to ascertain if the force the defendant used was or was not necessary to terminate the threat. So there are a few important things to take into consideration in conducting this analysis. And number one, this analysis is conducted before you can get to any of the charges. Number two, you can't use facts surrounding Kyle Rittenhouse's use of self-defense for any other person that may have attacked him other than the person identified in the count alleged in the criminal complaint that is being analyzed by the jury at that particular time. So, for example, in count 3, for intentional homicide related to the deceased individual, Mr. Huber, the jury can only assess facts surrounding actions of Kyle Rittenhouse and Mr. Huber only, and not anyone else during that point in time. Now, the facts from the testimony and the video evidence reveals that as Kyle Rittenhouse was running away from attackers, Mr. Huber hit him in the neck with a skateboard, and someone hit him in the back of the head with a rock, causing him to stumble. And a man tried to kick him in the face after he went down, he said. In his testimony, Mr. Rittenhouse stated that he was able to get up and run away again, but Huber hit him in the neck again with the skateboard and grabbed his gun. Mr. Huber stated that he could feel the gun sling coming off his body, and he fired one shot at Mr. Huber. While the jury can enter a finding of guilt on a lesser charge if they determine that the amount of force used by Kyle Rittenhouse was unreasonable, you must remember that the assessment is not only on fear of death, but also on fear of great bodily injury or great bodily harm. So the law states that Kyle Rittenhouse had the right to use the amount of force necessary to terminate the threat of death or great bodily injury or great bodily harm. Now, the prosecution is trying to raise the issue that Rittenhouse provoked everyone at the protest by being there with an AR-style weapon, and that as a result, he can assert self-defense because he provoked the attack. And so he's seeking to advance this provocation assertion for the jury to consider as well. But in my opinion, provocation means actually provoking each separate person. And so the assessment has to go to each encounter with each person, and not necessarily to Kyle Rittenhouse's state of mind before he even arrived, which is really the prosecutor's opinion, since I haven't seen any facts that have been placed into evidence to support this. Now, in my last video, I talked to you how important the analysis of intent to kill is and how the prosecution failed in its attempts to prove up intent to kill during its cross-examination of Kyle Rittenhouse.
Everybody that you shot at that night, you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them.
I did what I had to do to stop the person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force.
I used deadly force.
That you knew was going to kill.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
yes.
Correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
But I also want to show you that the analysis of intent to kill also shows up in that self-defense analysis as well. As you can see, before you can get to the question of whether the force used was reasonable or not, you have to make the determination that Kyle Rittenhouse intended to kill. And for this reason, in my opinion, it may be difficult for the jury to select a lesser charge that requires a finding that Kyle Rittenhouse intended to kill. The only other lesser charge selection that does not involve this type of analysis is the first-degree reckless homicide selection. And so in my opinion, it is more likely that if the jury is going to select either one of these lesser charge options, that it may likely select this first-degree reckless homicide selection because it does not involve a finding of intent to kill. Now remember, my opinion on this is only as it relates to count 3 regarding Mr. Huber. So you have to do the deliberation for each one of the counts because the facts regarding self-defense are different for each one. Obviously, Kyle Rittenhouse's chances are much better of prevailing on the attempted homicide charge in count 4 relating to Gage Grosskreutz because his self-defense assertion is more promising since Mr. Grosskreutz testified that Kyle Rittenhouse did not shoot him until Mr. Grosskreutz raised his gun and pointed it at Kyle Rittenhouse. And so here is a copy of the pattern jury instruction for attempted homicide as alleged in count 4 regarding Mr. Grosskreutz. And in its analysis of self-defense for this particular account, the jury can find that the defendant is not guilty of either attempted first or second degree intentional homicide if the defendant 1 believed that he was preventing or terminating an unlawful interference with his person, and 2, he believed the force used was necessary to prevent imminent death or great bodily harm to himself. Or the jury can find on this particular count that the defendant is guilty of attempted second-degree intentional homicide if the defendant actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. So in this particular case, again, the jury can find that the defendant is guilty of attempted second-degree homicide. So the jury has quite a job here. And I'll say again, even though there are very strong facts on the issue of affirmative defense, of self-defense, you have 2 deceased individuals. While I believe that Rittenhouse would absolutely be dead right now if he did not fire his weapon, I'll say again that you can never know what a jury might do. Now, in my opinion, I don't see how he could have come out alive by using any lesser or non-deadly force. But again, a jury is a very tricky thing to gauge. And I'll say this again, that it is possible that the whole thing could result in a hung jury. And this might even be the easier thing for the jury to do under so much pressure. But to do this, the jury would have to completely ignore the entire self-defense analysis. But we'll know soon what the jury decides in this case, and we'll just have to wait to find out. But until then, if you've enjoyed this video, please give me a big thumbs up. And please also subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos on this topic. And please also follow me on TikTok and Instagram.